facing the police every single day.
Today.
Of course, it should be unconstitutional for officers to come into your house and have a warrant and then steal your property.
Well, Fresno police are accused of stealing hundreds of thousands of dollars, but judges say they cannot be sued for it. Two businessmen sued over the alleged theft involving a now disgraced police officer. But if they're going to win, they might have to take the case to the Supreme Court.
Action News anchor Corin Hoggard shows us why the judges say the Constitution doesn't protect us from officers who steal. It's a story you'll see only on Action News.
Fresno police raids at their homes and business turned up some evidence of a possible illegal gambling operation involving coin pusher machines. And according to the police, it turned up about $50,000 in cash. But Britton Ashton and Micah Jessup say the officers took much more from their legal ATM business.
This was the perfect case to prove what, in my opinion, happens all too often, that officers go beyond the scope of the search warrant and steal property when they are going into people's homes.
Kevin Little filed a civil rights lawsuit for Ashton and Jessup, claiming the officers took more than $150,000 in cash, plus $125,000 in rare coins. The suit targets the city of Fresno and Officer Derek Kumagai, who they blame for stealing the coins and maybe more. He later went to prison for accepting a bribe from a suspected drug dealer. But in this case, the Ninth Circuit Court of Appeals in San Francisco ruled in favor of the city and the officers. The opinion says there's no clear law holding that police violate the Fourth Amendment protection against illegal search and seizure or the 14th Amendment right to due process when they steal property while serving a search warrant.
That's preposterous, and I think that's a travesty of justice. If police officers come into your house or into your business and follow up with a search warrant, that's fine. They can do that. But they have to follow the rules and regulations. They can't steal money.
Legal analyst Tony Capozzi says the judges are ruling the officers have qualified immunity, which protects police when they're doing their jobs. But this case could end up in the Supreme Court, which could refine the rules for qualified immunity.
The reason why this opinion has, I think, caught so much attention is that it's contrary to what our gut as citizens tell us.
Even with the Supreme Court of the United States, which is conservative at this point in time, they will reverse this case. Because I think the common feeling now is you can't allow this type of activity to happen.
Justices Sonia Sotomayor and Clarence Thomas have both expressed concerns about qualified immunity, but it could be months before they decide whether to hear this case. The city attorney's office said it couldn't comment, and prosecutors never filed criminal charges against Ashton or Jessup. Corin Hoggard, ABC 30, Action News.
California cops who allegedly stole over $200,000 can't be sued, court rules. By Nardo Saraya. 16 HRS. Edited. Two men claim cops stole over $200K from their business, but a court ruled the cops could not have known that was wrong. For the second time in the same case, a court ruled 3 Fresno cops accused of stealing more than $200,000 from 2 businessmen cannot be sued because the Constitution does not explicitly protect people from their property being stolen during a search and seizure. The Ninth Circuit Court of Appeals ruled this month that even if the allegations are true, the cops can't be held accountable for falsely reporting they only seized $50,000 in assets from Micah Jessup and Britton Ashton, despite the men claiming the cops actually took $151,380 in cash and another $125,000 in rare coins. Jessup and Ashton believe officers Derek Kumagai, Kurt Chastain, and Tomasz Cantu pocketed the difference during the 2013 raid. In a separate case, Kumagai ended up sentenced to prison in 2015 for accepting a $20,000 bribe from a drug dealer. In this case, the cops are being protected by a legal loophole known as qualified immunity that allows government officials to get away with crimes regular people would never be able to. Officials have been able to get away with firing a gun into a group of teens, forcing a 4-year-old to be strip searched without consent and even shooting a 10-year-old boy while trying to kill his dog. The court believed that because there was no clearly established law holding that officers violate the 4th or 14th Amendment when they steal property that is seized pursuant to a warrant, the cops shouldn't have to pay the price of committing a crime. In September 2013, the Fresno Police Department obtained a search warrant to look into 3 properties owned by Jessup and Ashjian in an effort to crack down on illegal gambling and money laundering. The warrant authorized the seizure of money, furniture, or machines that may have been used illegally. The cops conducting the search warrant gave the 2 businessmen an inventory sheet listing out what and how much they seized, except Jessup and Ashjian claimed to have lost much more. They filed a lawsuit against the cops and the city of Fresno arguing their 4th and 14th Amendment rights had been violated. The 4th Amendment protects people from unreasonable searches and seizures while the 14th Amendment requires due process of the law before any property is seized. However, according to the court, the allegation of any theft by police officers, most certainly the theft of over $225,000, is undoubtedly deeply disturbing. Whether that conduct violates the 4th Amendment's prohibition on unreasonable searches and seizures, however, is not obvious. Their answers were no different when it came to the question of possible 14th Amendment rights violations. Because the city officers could not have known that their actions violated the 14th Amendment's substantive due process clause, they are entitled to qualified immunity against Jessup and Ashjian's 14th Amendment claim. The court's ruling goes on to say they feel bad for the 2 men missing hundreds of thousands of dollars, but not all conduct that is improper or morally wrong, however, violates the Constitution. Typically what happens in qualified immunity cases is once a government official is granted impunity, the next official to commit that same crime is no longer protected under the legal loophole because there is finally an established precedent that says, stealing is wrong or something along those lines. But because the court found these California cops never violated the 4th and 14th Amendment, the possibility of future officials getting away with stealing a person's money and property has increased that much more. Understandably outraged by the court's ruling, the National Police Accountability Project, Institute for Justice and many other organizations have rallied for the petition for Jessup and Ashjian's case to be heard before the court en banc. If approved, every judge within the 9th Circuit Court would hear and rule on their case rather than a select few on a panel. Qualified immunity's place in the United States legal system has been questioned by Supreme Court Judges Clarence Thomas and Sonia Sotomayor, who called it a shoot first, think later approach to policing. During the second round of Democratic debates, presidential candidate Julian Castro said, "We need to have a standard and that we end qualified immunity for police officers so we can hold them accountable." Read the court decision here.
Hey Sheriff County, this is Sheriff County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.